like there's $558 in administration fees, $2,092.37 in assessments, $5,232 in attorney's fees, $289, 91 cents in costs, $186.75 in interest, and $198.27 in late fees, for a total balance.
And the parties are aware that this is a default judgment and that we are here to talk about damages. Is that understood, Ms. Robinson?
Yes.
Okay, perfect. All right. And so, Attorney Calvo, I will let you present your case on damages.
Sure thing, Your Honor. I do just want to recount the procedural history just to briefly establish a default here.
Okay.
I filed this complaint in May of 2025. And then thereafter, the summons for this complaint was addressed to Ms. Robinson at her residence at 509 Cross Creek Point. The service was made according to the deputy's return of service. Service was done in person at the address of 509 Cross Creek Point on Ms. Robinson's husband, who I believe is listed as Robert Robinson on the entry of service on file with the court. So that service was made on June 5th, 2025. The answer would have been due by July 5th, 2025. Time to open default would have expired on July 20th, 2025. But no answer was filed by Ms. Robinson by that time. And so we filed for default on July 23rd, 2025. And then we also filed an amended motion just updating the amounts of our request on January 5th of 2026. And so with that, I would call Ms. Willis to testify as to the amounts currently owed on that balance. And Your Honor, is it okay if I share my screen?
Yes, if we can provide permission for Mr. Calvo to share. Do you have permission?
Ms. Willis, could you just briefly state your name and your position with the Waters Edge Homeowners Association?
My name is Carla Willis. I'm the president of the Waters Edge HOA.
And Ms. Willis, I'm showing you what's been labeled here as Plaintiff's Exhibit 4. Do you recognize this document?
Yes, it's the homeowner's ledger.
And is this a true and accurate copy of the homeowner's ledger maintained by Homeowners Management Services?
Yes.
And at the time that this ledger was made, was HMS acting as a property manager for the association?
Yes.
And were these records made by a person with firsthand knowledge of this homeowner's account?
Yes.
And were these records made near or at the time the payments reflected on this ledger were due?
Yes.
And were these records kept in the course of the regular business of the association?
Yes.
Okay, I want to scroll here on Exhibit 4 down to the last page. I believe it's page 4. And do you see here, I can zoom in if necessary here. Let me zoom in a little bit. Do you see here what reflects a credit card payment that was made on November 28th, 2023?
Yes.
And at that time when that payment was made, the homeowner's balance with the association was 0. Is that correct?
That's correct.
And is that the last point, and I can keep scrolling through here, is that the last point on this ledger that Ms. Robinson had a 0 balance with the association?
Yes, the balance would be reflected in the latter column.
And so can you tell me what the regular assessments are for the association?
So we're billed quarterly. They should be $283. They're listed there. The first one that you see is April 3rd, 2024. It's $283.25.
And so it appears that after making that payment on November 28th, 2023, Ms. Robinson failed, or there was a charge for the assessment for January of 2024.
Correct.
And then it also looks here that I see on January 30th, 2024, there is a returned check charge. Would you mind explaining what that charge reflects?
So we rent out our clubhouse. We do require there to be a check that's provided. So this is a return check fee because the payment bounced back.
Understood. And so, and then I noticed here the next payment that was made by Ms. Robinson looks like it was made on April 3rd, 2024. Is that right?
Yes, it looks like the payment is for $283.25.
And at that point, did that payment still leave Ms. Robinson with a balance with the association of $833.66?
That's correct.
And then moving forward here, are all these charges that are reflected on the ledger for assessments, late fees, and interest, are those accurate?
Yes, they are.
And so this ledger ends on September 16th, 2024. Did the association switch management companies at that time?
We did. So we moved from HMS to CMA.
Understood. And then the final balance reflected here, that amount is $909.01 as of September 16th, 2024.
Correct.
Okay, now I'm going to show you what's been labeled as Plaintiff's Exhibit 5. Do you recognize this document?
Yes, this is the ledger that's maintained by Williams Law Group, our attorney for the HOA.
And so would this be the ledger for Ms. Robinson after her account was turned over to collections with our firm?
Yes.
And then I see here, if you look at this fourth line on August 31st, 2024, what is the balance at that time was $905.74. Is that right?
That's correct.
And so would that basically be the same balance from the previous ledger carried over when it was sent to collections?
Yes.
And then this continues to have to show the assessments, late fees, and interest charges since October 1st, 2024. Is that right?
Correct.
And I'm going to scroll through here. Does this ledger show that any payments were received from Ms. Robinson after October 2024?
No, the payment field reads 0 in the column that says payments.
And to be clear, are the records on this ledger also made by a person with firsthand knowledge of Ms. Robinson's account?
Yes.
And are these records also kept in the regular course of business of the association?
Yes.
And I see here the final account balance listed as of February 17th, 2026. It looks like there's $558 in administration fees, $2,092.37 in assessments, $5,232 in attorney's fees, $289.91 in costs, $186.75 in interest, and $198.27 in late fees, for a total balance of $8,557.30. Is that a true and correct statement of Ms. Robinson's balance as of?
Yes, it is.
Oh, excuse me. Go ahead.
Yes, that is the true and accurate reflection of her balance at this point.
And did the association retain the services of the Williams Law Group to represent them in bringing this action to collect these unpaid assessments?
Yes.
And is the association responsible for attorney's fees incurred by the Williams Law Group?
Yes, we pay all attorney's fees up front.
Thank you. Your Honor, I have no further questions for this witness, but I would like to offer some testimony of my own regarding the rates and attorney's fees charged by the firm, if that's all right.
Yes, you can.
Thank you, Your Honor. So my name is Patrick Calvo. I'm a senior associate with the Williams Law Group. The firm retained our firm is retained by the association to represent them in their collection matters, including this case. As part of that representation, our office sent multiple demand letters to Ms. Robinson as far back as, I believe, in March 2025. So a few months before bringing this action, we sent multiple demand letters to Ms. Robinson's home regarding the past due balance. We also drafted and filed a notice of lien for the unpaid assessments. We drafted and filed the complaint in this action and the motion for default after no answer was received. We did have a previous hearing in this case where I spoke and mediated with Ms. Robinson in an attempt to reach an agreement on January 8th. And even after that, I continued to have multiple email conversations with Ms. Robinson to address her concerns with service in this case and to attempt to resolve the balance, but unfortunately weren't able to come to resolution. And so the charges or the rates charged by our firm are $300 an hour for senior associates like myself, and then $150 an hour for paralegal work. And so the attorney's fees entries on this ledger are made by members of my firm at the time that they perform the actions in representing the association. And they are true and accurate statements of the activities performed by paralegals and by attorneys. One thing I would note here is that a majority of the attorney's fees incurred in this action were incurred during and after the January hearing. We made a lot of attempts to resolve these issues. I had a lot of communications with Robinson and sent her over copies of the proceedings demonstrating service and everything. And so that's a lot of the reason for the attorney's fees incurred in this case. But unfortunately, we just weren't able to get it resolved. The only other thing I'd say is that these attorneys are customary and reasonable in the Metro Atlanta area. I have several years of experience representing associations in litigation cases, as well as representing homeowners in HOA cases. And so today we would be seeking that the court award this full $8,557.30. And I would also seek the attorney's fees incurred by the association today, which are not reflected in this ledger. And so today I spent about 3 hours preparing for this hearing, and it's about 6:54 right now, so about 1 hour at this hearing. So 4 hours at $300 an hour would be an additional $1,200. And so we would be seeking $9,757.30 today.
Attorney Calvo, I know that your client mentioned that. I just want to confirm, you're saying that these attorney's fees have been paid? I know outside of the ones that you're asking for today.
Yes, that's correct, Your Honor. Those attorney's fees have been incurred by the association, have been paid, other than the time I have spent today, which has not yet been billed.
Okay. Is it typical to pay more for attorney's fees than the actual debt?
Your Honor, what I would note here is that at the time we initially took over this matter, the balance was only about $2,000.
Mm-hmm.
We sent a notice to Ms. Robinson back in March of 2025, indicating that her balance was $2,000, providing her with payment instructions so that she can direct payment to our firm. Unfortunately, nothing happened. So we had to file this complaint in May. We served in May. We had to file a motion for default judgment. And again, a large reason for the additional attorney's fees, as can be kind of shown on the second to last page and the third to last page of this ledger, are that I had to appear for the original hearing in January of this year. That mediation and hearing took, if you'll give me a second, let me confirm the exact amount of time here. So it looks like that took a little under an hour, resulting in a charge of $210 to the association. After that, we were not able to get it resolved, and this court granted Ms. Robinson a one-time continuance so she could seek counsel. In the month following, I had, again, multiple email conversations with Ms. Robinson to try and address her concerns regarding the fees that are incurred on her account, as well as service in this case. And it was a back and forth. Including reviewing documents submitted by Ms. Robinson. But unfortunately, despite all that time, it just came to be that Ms. Robinson did not seem to intend to resolve this case with us, and we had to go forward today. And so what I would say is that it is typical to incur significant amounts of attorney's fees in bringing these collection efforts, which is why the Act provides that we can recover those fees. And a lot of these, in this case, were the result of us trying to get this resolved without moving forward with the hearing, but just unfortunately that didn't happen.
Okay. All right. And Ms. Robinson, do you have any questions for Ms. Willis, or do you want to just present your case?
I do just have one question for
Okay.
Ms. Willis. Why were my payments that I sent to the address and here in Commerce, Georgia, which I submitted that information, those payments were rejected by the bank? And do you have any reason and do you have any knowledge of why that occurred by your bank?
So, as we stated, we were with HMS, which is a management company, through August of 2024. Once the management company terminates a relationship with the HOA, they are under, the instruction is to return any payments that were made by homeowners in that community back to the client, right? Back to the homeowner. The same is true when we move to CMA. So as you have the letter there, CMA actually terminated their relationship with us on November the 14th, 2025. However, I will note that when you got information from WLG, anybody who was in collections, it's very clear on the documents that you are to only talk to and make payments through WLG. So when your account is turned over to the collection attorneys, they are the ones that continue to maintain the ledger. We do not get involved in the receipt of payments because, as Attorney Calvo just explained, there are these back and forth conversations that happen between the homeowner and the attorney's firm that we're not privy to. So we don't receive any payments once your account is turned over to the attorney. So I guess there's two parts to your question. The first part is, when we left HMS, if you were trying to make a payment to them, then they did exactly what they were supposed to do. They gave you your check back. However, by that time, I think you would have been in collections. So all of the payments should have gone to WLG anyway. And I hope that answers your question.
Well, that is helpful.
All right, Ms. Robinson, any other questions for Ms. Willis?
No.
Okay, real quick, before I let you go forward with your defense, Attorney Leahy, let me check in with you so you don't have to sit through this. Did you have a chance to submit that consent agreement?
Yes, and your clerk has confirmed that it was accepted.
Perfect. All right, thank you. Well, did we take care of all of your matters? That was the last one.
Yes.
Okay.
Yes.
All right. Well, have a great night.
All right. Thank you. You
You're
too, Your
welcome.
Honor.
Thank you. All right. I apologize, Ms. Robinson, but you may proceed with your response.
Okay. Thank you so much. First, I would like to state that I did have a court appearance that I missed, but that is because the address on the summons, on the back page of the summons, had the wrong address on it. It had an address for Harbor Cove, but I'm just going to read my statement so I don't get distracted.
Okay.
Let's see here. I was unable to attend the scheduled court date on the date I missed court due to a significant failure in service process. The summons and court information had the incorrect address, that is neither my residence nor one associated with me. And this led to confusion on my part as it related to my legal obligations. I did not think the court date applied to me, but rather to the person that resides at the address at Harbor Cove, which was listed on the back of the summons. It did come to my house. And as you can see from the ledger, we do pay our HOA dues and our bills quite regularly. However, we were transitioning to me picking up the bill from my husband. So that's why, but when I picked up the bill, I had sent 2 payments, which were returned. And then and I had been reaching out for assistance with that, but sorry, let me go back. Because I did not receive timely or proper notice, I was denied the opportunity to present a meritorious defense. Furthermore, the amount claimed by the plaintiffs was so significantly inflated by unexplained fees that I initially believed the correspondence was intended for a different individual. At the time that my account was sent to their collections office, I had missed 2 payments. I missed 2 quarterly payments. And those payments were returned by Wells Fargo Bank because I did not know why at the time. When I called the office and spoke to whoever works in the office for the HOA. She told me to go in, delete the bill pay, and resubmit it. And I have submitted to the court that I have continued to try to make the quarterly payments of $285. But I do acknowledge at this point, my balance is approximately $2,000 because by the time the attorneys got the case, I owed them $900 and $1,000 in attorney's fees. And they said this was an effort to collect the debt. So it was a debt trap. At that point, there was nothing I could really do but do that. But so when I got the communications from the attorneys, at that point I owed $2,000. When I was $1,000, we had missed two payments because the address had changed. I have consistently attempted to pay my dues via the Wells Fargo automatic bill pay, and I have attached the bank records to prove these transactions. Water's HOA repeatedly rejected these payments without cause. I didn't know the reason. The HOA changed. They have changed the payment address and the payment instructions 3 or 4 times in the last 3 or 4 years, and it is not effectively communicated to the homeowners. They don't have a newsletter that come out. They don't have some kind of official, effective manner of communicating with us about these changes. And so I'm a teacher. I'm paid once a month regularly, and I pay my bills on a regular schedule. They did not properly communicate with me as a homeowner about these changes. But so I kept calling the office and saying, I didn't know why the payment wasn't going through. They never said in the office that they had changed to a different provider or anything like that. Incorrect billing instructions. During our meeting in January with Mr. Calvo, the HOA representative, Mr. Calvo, claimed that he was unaware of the Commerce address that I used to make payments. He even stopped and went and talked with Ms. Willis, and they came back and they said they had no idea where the Commerce address, and this is the address. So I think Ms. Carla Willis may be new in her role, but that is the address that I was given, and I don't know if there was an error where I continue to receive coupons after the date that we were not supposed to pay them anymore by the coupons.
Today we are stepping into a courtroom where the outcome is already leaning in one direction. The judge makes it clear this is not about who is right or wrong anymore. That decision has effectively been made due to a missed response. Now the entire focus shifts to damages, and that changes everything. This is the legal moment many people misunderstand until it is too late. Silence in the early stage can cost far more than the original dispute. You can already sense the imbalance forming before a single number is spoken. The atmosphere is calm, but the stakes are quietly enormous. What follows is not a trial, but the financial unraveling of one.
And I've attached the HOA's own billing coupons, which explicitly lists the exact address where the payments should be submitted. It is a misrepresentation of my account status to provide an address in writing and then sue me for following the instructions that I was receiving on the coupons. These coupon books, they've changed everything. When my first payment was returned, I proactively contacted the HOA to seek guidance on how to ensure my dues were being received correctly. During that conversation, the HOA representative specifically recommended that I delete the existing payment entry in my bill pay software and re-enter it from scratch to refresh the connection. I followed those instructions as she gave them, and so that is the only stub that I'm missing on my Wells Fargo is just the January, missing the quarterly payment. That's the single missing record, and it's a direct consequence of following the technical assistance I received when I called the HOA office. Lack of notice for billing changes. At some point in 2024, 2025, the HOA switched how they were doing their billing. I received undated and unaddressed notices in my mailbox stating the billing agency had changed yet again. Even now, Judge, which I know I owe them the money and I'm probably going to lose, but I was like, I need you as a judge to understand what the HOA is doing in Water's Edge subdivision. Because in my mailbox on January 15th, a week after we came to court, there was a new notice placed in my mailbox, undated with no signature, saying that there was even a third new billing thing that we're supposed to do now. And I'm like, I know I got to pay them, but you need to know what's going on in Water's Edge. Lack of notice for billing changes. There is not proper notice of these changes, okay? And Georgia Property Owners Association Act, there are some guidelines that they need to follow. Although a change was listed, it was never explained what the effective date of the change would be and how to handle payments that were already en route or returned. And this is what Ms. Willis just said. She explained that in August they terminated. However, most of us set up our bill pays and whatnot for an annual cycle of things. They terminated in August. They did not provide the homeowners proper notice of these changes. In my effort to rectify these billing discrepancies, I was repeatedly rebuffed by the HOA, and I was told that I only had to deal with their legal counsel. And then, as Mr. Calvo keeps saying, every time I call or reach out to him to defend myself and present my case, the legal bills are going up. So it's like it's impossible. So I am requesting that I bring my current balance current immediately. I'm ready to pay today the $2,200 or so that I owe, including the late fees, I acknowledge. However, I do not think that they should be rewarded, Judge, as the HOA for this irregular pattern of billing. It's not fair to the homeowners, okay? And then the fees and the fines and the legals far outweighs the money that I owed. When I owed $1,000, I had missed 2 quarterly payments at that point, and then received $1,000 in legal fees. Now that, and then why do I owe them $2,000 now? It's because I'm not able to pay them. I have to wait to come to court to pay. I can't pay them. I have to only deal with the attorneys. So that's not fair either, because I'm disputing the old stuff. Once I got the new address, I would have been paying them the $2,000. So I owe them $2,000 and $8,000 or $9,000 in legal fines. This is not fair. And this is, and if there is any judgment because I missed the court case, that's not right, because I was improperly served. And I ask you, Judge, to please dismiss all claims from the attorney fees, late fees, and any attorney fees, as I have documented proof of my attempted payments to address this matter. And I request that you direct the HOA to provide a single verified and correct billing statement and directions for payments to all the homeowners in the association. And I also want to address that I was told when I called, they told me to come to the town hall meetings, that's where they disseminate a lot of this essential information. They're not communicating it through a proper newsletter or communication. And the mail that they send is undated, which I've provided and uploaded to the court as well. That's the main thing, because I am going to still live in the subdivision and I do want to pay my bills regularly and on time. There is an ongoing failure of this HOA to provide stable and adequate notice to the residents in regards to these changes with billing, the address, the method, etc. And I think that it's been very, very, very aggressive debt collection that far outweighs missing 2 quarterly payments.
Okay.
So thank you for your time. I appreciate it very much.
Thank you, Ms. Robinson. I do want to note briefly, you did ask that I make a ruling concerning how you're making your payments. That's something that's out of my jurisdiction. In magistrate court, the only jurisdiction that I have is to issue judgments under $15,000 or less. So I can't force anyone or make any type of ruling that, the relief that you requested. I just wanted to make sure you understood that.
Thank you.
You're welcome. Attorney Calvo, do you have any questions for Ms. Robinson?
Yes, Your Honor, briefly.
Okay, go ahead.
All right, guys, this section lays out the procedural timeline, and it is far more important than it sounds. The attorney walks the court through dates, filings, and deadlines with surgical precision. Each date represents an opportunity that passed without action. In civil law, missing a response is not a small mistake. It is a turning point. The system interprets inaction as acceptance, whether intended or not. What we are watching is how paperwork becomes power. There is no drama here, just methodical explanation, which is exactly what makes it so serious. The foundation is being built to justify everything that comes next. Once the timeline is locked in, reversing it becomes nearly impossible. This is how cases are often decided long before anyone enters a courtroom.
Ms. Robinson, I want to begin by sharing my screen, showing you what's been labeled as Plaintiff's Exhibit 8. So this is Plaintiff's Exhibit 8. Ms. Robinson, do you recognize this letter?
Yes,
You do? Did you receive this letter in the mail?
yes,
Okay, I want to, and this letter is dated March 12th, 2025. Is that right?
yes.
I want to scroll down to the second page here. This first full paragraph, this says that payments can be made by certified check, cashier's check, or money order payable to the Water's Edge Homeowners Association delivered to this office. Alternatively, you may also make your payment online by credit/debit card or e-check. If you wish to make your payment online, please visit our website at www.thewlgfirm.com. Click the HOA payments link at the top of the home page and enter your unique client ID. Do you see that?
Yes.
Did you attempt to make a payment at that website at that time that you received this letter?
I did not attempt to pay on the website. I did reach out to Carissa Johnson, who is listed there, and she indicated that this was an effort to collect the debt and the full amount was due, which was $900 in my outstanding dues and over $1,000 in legal fees and fines. And so that's why I did not make the payments, because that's what she said that was due, which I did not think the legal fees and fines were fair when the HOA had not properly communicated the address, the billing changes, the billing procedures, and the billing addresses. You guys are getting paid
Thank you, Ms.
to
Robinson.
change.
Ms. Robinson, that does
things.
answer the question. Attorney Calvo, do you have any other questions?
Just very briefly, Ms. Robinson, you said there were two payments that were missed. Can you tell me which payments those were? What were the months that those payments were due?
The 2 quarterly payments, which would have been, and here on our statement, we can see for the July 17th payment, we made a payment. The only time where there was we completely fell off was when I made a payment July 14th. You see that?
What year, Ms. Robinson?
July 2024, July 17th, the statement right here, July 17th.
So which payments were missed was the question.
So that would have been the quarterly payment for maybe September, I guess, and then December.
Of 2024.
Yes. And then possibly January, depending on when, and I spoke to someone February saying this was Emmy Marshall with community management. This is the coupon book now. This is different than these people. The coupon book. She said she was going to research it because I told her, I know I had missed 2 payments, but I saw this $400 fine. I saw this other miscellaneous fine. And she said she was going to research it.
All right, now we begin to see how an ordinary homeowner account transformed into a legal conflict. The ledger is introduced, and numbers start telling a story more persuasive than opinions. At one point, the balance was 0, which immediately reframes the narrative. This did not begin as a massive debt, but as routine assessments. Then missed payments, added charges, and a bounced check created momentum. Financial disputes rarely explode overnight. They accumulate quietly. Each small entry becomes a stepping stone toward escalation.
So
Okay.
at that point, by the time I didn't hear back from her anymore, then I went to the attorneys.
Okay. Attorney Calvo?
So, Ms. Robinson, you said the 2 missed payments you believe were both in I guess the end of
The
2020.
last, yes, 1 or 2, what it would have been, I guess it's quarterly payments. So September-ish, December.
So are you contending that you made a payment to the association in January of 2024?
I did not. I spoke to Emmy in February. I spoke to Emmy February 2025 and told her I had been trying to make the payments. I had 2 payments rejected by Wells Fargo Bank. Emmy did not say, she didn't say anything. And then she said she was going to research it. And then the next communication was with your attorneys. Now, since that point, I would have been making payments in the coupon book. However, I was only supposed to deal with the attorneys, but pay double what I owed because of legal fees. When I tried to make some payments with this, we find out the HOA has changed it yet again. It's no longer with the coupon books. I made 3 payments here in this coupon book. Those payments were returned because the judge, they didn't even finish out the year with the coupon books. Even though they sent us coupon books, they didn't finish out the year with the coupon books. They're not communicating with the homeowners. They were sued.
I understand, Ms. Robinson. This is just for you to answer his questions.
Yeah.
So, Ms. Robinson, you said there were 2 payments that you missed in 2024 and then also January. So that's a total of 3 missed quarterly payments in 2024. Is that right?
Yes, $283. 3
Okay, let me
missed payments.
let me just make sure I understand the question. Attorney Calvert, are you talking about January 2024 or January 2025?
4. I'm
Okay.
talking January 2024.
Okay, because she's saying January 2025. I just want to make sure y'all are on the same page.
Oh, yeah.
So, okay, let me go back to my original question then, because my question was, did you make a payment in January 2024?
Yes, we were paying. When do you even show that we were at a zero balance? You mentioned when we were at a zero balance.
That was in November of 2023. So that's why my question is, did you
Yes,
make a
I have a payment here, July 2024.
He's asking about January 2024, Ms. Robinson.
Buckle up, because this is where the situation accelerates from unpaid dues into full collection mode. Management changes, the account is transferred, and suddenly attorneys enter the equation. That transition alone often multiplies consequences, regardless of the original amount. The numbers begin to stack in categories: assessments, fees, interest, costs. And then comes the figure that captures the room's attention. The balance has grown far beyond the initial obligation. This is the moment many viewers realize how administrative escalation works. Once an account is routed into collections, the process becomes procedural rather than personal. Opportunities to resolve shrink while expenses expand. The financial gravity of the case is now impossible to ignore.
I don't know about that. I don't have that one in front of me, but I do have April 2024.
He's asking for specific questions.
Okay.
The questions,
So
if you're able.
I don't know. I'm sorry.
Okay.
You're fine. I'm just trying to clarify again what payments we're talking about. So you said there were 2 payments at the end, 2 quarterly payments at the latter half of 2024 that you missed. And then we just talked about January 2024, right? So that's 3 quarterly payments in 2024. And so now going on to 2025, you said at that time the
Yes.
account was with our firm, correct?
Yes, exactly.
Did you make any quarterly payments to our firm in 2025?
Did I to your firm? No.
Okay.
You did not ask me for any quarterly payments. You asked me to settle the balance of what was due. You did not ask for any quarterly payments, or I would have made you quarterly payments. While we were disputing the debt, I would have still been paying my dues. I haven't changed it yet. I'm still paying. I'm still making payments to community
Ms.
associates.
Robinson, you have to stop after the answer to the question.
Sorry.
I understand you're trying to get your point across, but he's asking questions that you just need to stick to the answer for me.
Okay, sorry.
Okay, so that's 3 payments in 2024, and then I guess all 4 quarterly payments in 2025. And so the last one I want to ask about is, did you make a payment to our firm in January of 2026 for this first quarter of January 2026?
No, I haven't been asked to make a payment to you guys in January 2026.
All right, here the attorney explains why the legal fees now rival and even exceed the underlying debt. Preparation time, filings, mediation attempts, correspondence, all translated into billable hours. The court hears not just what was owed, but what it cost to pursue it. This is where law and economics intersect in a way that feels uncomfortable to many observers. The judge even questions whether such fee imbalance is typical. The answer reveals a reality of civil litigation that surprises people. Legal enforcement can become more expensive than the issue being enforced. Intent no longer matters as much as documented effort and time spent. What sounds like justification is actually standard legal mechanics. And those mechanics can be unforgiving once activated.
Understood. Your Honor, I have no further questions for this witness.
All right, and can you submit those documents that you placed into evidence? I don't have a copy of the ledger that
I
you
did email all my
did.
exhibits to,
Okay.
which includes those exhibits as well.
I did not receive the ledger either.
Okay.
I
When did
believe
you
Ms.
email
Robinson
them?
is included on that email. I sent it at, give me one moment. I sent it at 5:56
Oh,
today.
today? Okay, thank
Okay.
you.
All right, and if you could place in the chat box which email address you sent it to, just want to
Sure.
make sure that we know where to look for it.
That's my first name, Patrick, at thewlgfirm.com. And I put it in the chat as well.
Well, I'm asking where you sent it. You said you sent it to us.
Yes, I sent it to Ms.
Well,
Robinson.
not
Small
we're
claims
on
court.
YouTube, so we don't speak out loud any email addresses if we can help it.
Sorry about that.
That's why I said if you could place it in the chat box, which email address you emailed it to our
Okay, I will put in the chat box the email addresses that I sent it to.
thank you.
It was the one on the hearing notice, I believe.
Got it.
It was I think it was in response to email that Ms. Robinson had sent.
Okay.
Just to make sure. And then I'll also send you want me to send in the chat the email that I have Ms. Robinson that I sent it to as well?
Ms. Robinson, I know you have your hand up. Did you receive the email?
Yes, I
Okay.
did at 6:11. Thank you.
You're
Or
welcome. And you
actually
had
5:56. Thank you.
all right, and you had a question?
I want to also say that when we left court earlier this last month, Mr. Calvo asked me for my email address at the end of the meeting. As we were, he asked me for my email address. He also emailed me. So I did not realize that communicating with him was racking up unnecessary legal fees. I would have just waited to come to court and speak to the judge. But he also reached out to me. He asked for my email address, and I was responding likewise to him. I have no desire to waste his time or money, or my time or money. And if I had known that I was racking up legal fees by giving him my email address to communicate with me, I wouldn't have done it. I would have just waited to present this case here. So again, I do not think I should be paying for their legal fees when they're aggressively going after homeowners who miss 2 or 3 payments.
All right. Is there any closing, Attorney Calvo?
Very briefly, Your Honor, I think most of the evidence speaks for itself. I do just want to emphasize, in the end, this is as Ms. Robinson even stipulated at the beginning, this is a hearing on damages, right? The defendant is already in default. I think we can distinguish here, if a payment is made and accepted, withdrawn from Ms. Robinson's account, of course, that's relevant to the question of damages, right? And to the amounts of damages. Respectfully, Ms. Robinson's arguments that
Now we hear directly from the homeowner, and the tone shifts from procedure to frustration. She describes confusion, changing payment systems, rejected transactions, and lack of clarity. Her argument is not that she owes nothing, but that the escalation was unfair. This is a clash between lived experience and institutional process. The court listens, but also reminds everyone of its limited role, because liability was already decided.
Communication could have been better, or that she shouldn't be liable due to confusion about a prior coupon book. That I think that goes to liability, and that was waived due to the failure to answer. But nonetheless, what the evidence shows here is that Ms. Robinson was receiving notices as to where she could make payments. She did receive a notice from our firm as to where she could make payments. And I would also note that the debt in this case began back in January of 2024. The timeline that she said she started to try and make payments, July of 2024, at that point, there was already a significant balance past due to the association. So even if every payment Ms. Robinson claims she tried to make since July 2024 had been properly tendered, she still would have had a balance. This collection still would have unfortunately been necessary, and these attorneys fees still would have been incurred. Thank you, Your Honor.
Thank you. And Ms. Robinson, I will let you have your closing as well.
My very first point, Judge, thank you for listening. And I do love the neighborhood. I'm very happy to be there, and I definitely want to pay our bills. And I think the ledger just does show that we had regularly paid our homeowners' dues until the transition in leadership with the HOA. Multiple changes in leadership. The homeowners sued the HOA. Lots of changes with the leadership, with payment addresses, failure to communicate the correct billing procedures, due dates, procedures for missed payments or past due payments, and then aggressive escalation to their legal offices, even despite the chaos of leadership. But no matter what, I would have come to court and bid here had my address. I was not properly served. And so the address on the service had another address on there. It had an address in Harbor Cove. So I did not think the debt was mine, and I did not know I was supposed to respond in 30 days. I did not think it was for me. I thought it belonged to the person at the other address.
Okay, let me briefly address that because I think we did not address the service issue. The affidavit of service that was filed, as Attorney Calvo stated, has a Cross Creek address, and it says that a Robert Robinson was served with a complaint. Is that what
Yes.
you're disputing?
That document was served to him, yes, but the last page, which is the service certificate of service, it had my name and a different address on the last page. So I told him, I said, I know they're sending this here. This must have to do with this other address. And that's improper service. It's confusing. I'm not a lawyer.
Okay, hold on one second. I'm trying to follow what you're.
The last page of the service had a different address on it. It had 754 Harbor Cove. Mr. Calvo, can you explain why that is? Is that a mistake you made or a mistake of the HOA?
The return of service in this case is dated June 5th and is, from what I see in the proceedings, is one page.
I'm not seeing the document that you're speaking of. I see the complaint that was filed with the court that outlines the issue. Let's see the statement of claim.
I would also note, Your Honor, the statement of claim has the summons on the bottom, and that summons is also addressed to 509 Cross Creek Point.
Am I able to share my screen?
You're not, but if you
Okay.
what document? If you can hold it up, I might be able to
This
see.
document is called
You
Plaintiff's
can
Amended Motion for Default Judgment. And on the last page, it has Certificate of Service,
okay.
Miriam
I
K.
figured we were.
Robinson. And so when I flip through this information, at this point, it's saying I owe them $4,000.
Got it. Okay. So I
And
think
I know that
Ms.
I owe
Robinson,
them
I can
maybe.
clarify. I can clear this up. So when we're saying you were in default, you're in default for failing to file an answer after being served in June of 2025. So not due to any amended motions for default judgment or not responding to their motion. This is from the initial time that the sheriff came out to serve your husband. From that date, you had 30 days to respond with an answer filed in the court. So because we did not receive that document, that's why you're in default. Not anything to do with that motion that was filed by the plaintiff in January of this year. And the documents that were filed, that were served on you back in 2025 do have the correct address, which is how they were able to serve you at that address.
On the certificate page as well?
I don't see
The certificate had the wrong address on there because when I flipped through this, I was like, this is not even me. This is not even our address.
Yes, Attorney Calvo, you wanted to.
Your Honor, if I may, this is coming back to the issue of the attorney's fees in this case, and why they continue to accrue following my attempts to speak of Ms. Robinson. I have attempted to speak of Ms. Robinson about this. I have sent her copies of the summons as well as copies of the entry of service you're looking at, and kind of as is happening today, it's just been a bit of a circle where, despite providing the evidence to her, for some reason there just doesn't seem to be an understanding that service was made on June 5th at her residence at 509 Crossview Point. And respectfully, I just would like to point out that this is an example of the kind of conduct that's resulted in the fees in this case. I've attempted in good faith to resolve this, but every time I try, we just kind of get a bit of a runaround with these issues.
Okay, so all of the documents that I have, Miss Robinson, that were served back in January of 2025, I'm sorry, that were served on June 10th, 2025, have the correct address. If you would like to hold up any document so I can try to clarify what certificate of service you're referring to.
I have it here on my computer.
Okay,
I
what
don't
is
know.
the title of the document?
It is, the page is called the Certificate of Service.
What is the title of the first page?
It says, in the Magistrate Court of DeKalb, State of Georgia, plaintiff's amended motion for default judgment.
Okay, so again, what I'm trying to explain to you is that service of that document is not why you're in default. So you did not have to respond to that document. What you had to respond to was back in June of 2025 when a sheriff actually came to your home and served your husband. From that date, you had 30 days to file an answer with the court. If you do not file an answer with the court, you are in default. So again, it does not have anything to do with that document that you're looking at. That document does not cause you to be in default. You did not even have to respond to that document. Okay?
Thank you.
You're welcome. All right, so I am going to take this case under advisement and issue an order, and you all will receive a copy of my order. It should not be longer than a week. And then if you, do you all have any questions before I let you go?
No problem, Your Honor. If there's any issue with viewing that email with the exhibits, just definitely feel free to email me my address and I provide them a chat, and I'm happy to send that over again if I need.
All right, thank you. And Ms. Walker, do you have access to that email address? Just to confirm that we received it. Yes.
Yes, I have access to it.
Okay. And can you check to see if you received that email from Attorney Calvo at I guess it was around
5:56.
5:56. And I have your email address as well, Ms. Robinson. Thank you.
Thank you. And if you have any questions, I can also clarify anything that
I have it.
that needs to be uploaded.
Okay. All right. Well, I have your documents that were filed with the I guess that January 9th answer, the late answer. I do have see that your exhibits are with that document, and we also have your documents as well, Attorney Calvo. So I will review all of those and issue an order accordingly. Do you all have any questions before I let you go?
Nothing further, Your Honor.
All right. Well, thank you all, and thank you, Ms. Willis. You all are excused. Have a great night.
Thank you. You as well.
Thank you. All right. Let's see. We have Is that Ms. Jones? You already spoke with Attorney Anson, Ms. Jones?
Yes, ma'am, I have. Thank you.
Okay. Did you all reach an agreement, or do you need a hearing this next?
We reached an agreement.
Okay. Have you signed that agreement?
I did, and I
Okay.
returned it back to him.
Gotcha. All right. Looks like so we're probably waiting to receive it unless Ms. Walker, you have received it.
Yeah. What position was that?
That's position 1.
Oh, yes. It's already uploaded.
Oh, perfect. All right. Let me just confirm 2 signatures. Yep, I have your signed document, Ms. Jones. So you are good to go. Have a great night.
Okay, you too. Stay safe.
You too. Thank you.
Okay, bye-bye.
All right. And we will be in recess until Attorney Osson returns.
Okay.